Hi, friends. Hello. How's everybody? Tonight we're going to have our live where I'm going to share with you some immigration news, provide my comments about the United States Supreme Court decision that affects immigrants, many of you. And of course, I will be answering your guys' questions live. So please join me. My name is Alena Shautsova. I'm an immigration attorney. I practice out of New York, but I help people in all 50 states and overseas. On my social media channels, I regularly hold these live sessions where I explain immigration news to you, inform you about the most recent, most interesting developments in immigration, and of course, I answer your guys' questions live. So please let me know where you're watching from. Like, share this stream. I hope you're doing well this weekend. We do have some interesting information to discuss, and it's very important that you stay on top of this news, especially if you are, or you've been rather, in removal proceedings at some point. Hi, Ali. Hi, Ahmed. Hi, Karina. Thank you guys for joining. Especially if you were in removal proceedings, especially if you had a removal order, recent a Supreme Court decision is very, very important for you to get updates on. All right. So let's start. And of course, today is going to be about parole in place. Hopefully, next week, Biden is going to announce parole in place program for spouses of US citizens. So I will answer here some of the questions that you guys have been asking me on my social media channels, important questions. And let's start with this decision first, all right? So let's start with this decision that was published, I believe, yesterday, June 14th, 2024. And the decision I'm referring to is Campos-Chaves versus Garland. I hope I pronounced the Chaves the right way. So what happened in that big case, and the case was large, very significant for the immigration community. It was a new issue that immigrants were trying to bring up before the United States Supreme Court related to defective notices to appear. A notice to appear is a charge against you that starts an immigration case against you in immigration court. So it's an extremely important document. Some time ago, the United States Supreme Court held that if a notice to appear issued against you by the government did not contain time and date when you were supposed to come to court, then it was defective. And as such, it had zero effect for something called stop time rule for cancellation of removal purposes. Cancellation of removal is one of the most popular reliefs that an immigrant is going to file in court for if they want to save themselves and not being deported out of the United States. You probably know it by the name of 10-year green card. Of course, it's not enough to be in the United States for 10 years. You also have to show that you've been a person of good moral character, that you have certain relatives in the United States who will suffer extreme hardship in case of your removal, and so on and so forth. You deserve discretion, but the 10-year mark is very important. It counts legally, not physically. For example, from the time you entered the United States until a notice to appear that was not defective is served, or until you are arrested for a criminal conduct of some sort, or you leave the United States, or you have an order of removal. So it's not 10 years physically, meaning that, for example, you entered the United States 20 years ago, but on the year number 2, you were placed in removal proceedings. Your time for the purposes of cancellation or removal was stopped at the 2-year mark if the notice to appear was sufficient. It had time and place. So now the new issue was about this. Pay attention. What if such a notice to appear was defective, but the person didn't show up to court and received an automatic removal? Many of you have this situation. Somebody gave you bad advice, or you moved, you didn't receive the notice to appear, and you received as a result an automatic order of removal. Now you cannot fix your status. If you leave the United States, you're also going to be for 10 years inadmissible, plus for 5 years you're going to face a permanent bar. In case somebody misses their removal proceedings, they cannot come back for 5 years, unless they can show that there was a good cause why they missed. So it's a very serious thing. A group of immigration attorneys, immigrants, gathered together and filed a lawsuit stating that if you missed the court date, but the notice to appear, that important document that called you to court, was defective, it means that proceedings were jurisdictionally flawed, and hence that order of removal that was issued against you by default should be invalid and rescinded. It would make sense, right? It would make sense to hold that, taking into consideration that we already have a similar ruling logically that said that defective notice to appear does not have effect on a stop time rule. But the United States Supreme Court held differently. There you go. So it said no. If you received the notice to appear, even if it was defective, and later you received a notice informing you about your proceedings and you didn't show up, then you didn't show up, and you have to bear the consequences of missing your court hearing. So that's the ruling that we're discussing. Many of you have motions to reopen pending, at least some of you, right? And some of you relied on this argument that notice to appear didn't have time and place, not only entitles you to cancellation or removal, the whole proceedings, the whole order of removal had to be rescinded. So no, don't blame your attorney if you get something other than approval of your notice of your motion to reopen. We cannot argue with the United States Supreme Court. Only if the Congress is going to pass a law that is going to be different from this ruling, then is going to be fixed. Up until then, the highest court has spoken. That's where we stand. So it's very important information. Parole in place. Let's talk about parole in place, immigration reform, immigration amnesty, however you want to call it, something that we, or many of you, are waiting for, because it will open the door to that green card, to that citizenship, and you won't have to leave the United States to fix your status. Currently, this relief is only available for those who are members of the family of the military personnel, former or present. It's said that Biden administration wants to expand this opportunity to spouses of US citizens. Some of you have this situation, right? You entered the United States illegally a long time ago. Now you have a family, you have strong relationships, strong family ties. You do have an opportunity to go with I-601A waiver, but it takes 4 years currently to use that opportunity. You may exercise cancellation of removal route, but it takes on average 8 years to do that. Plus, in both situations, you still have to show that your qualified family member is going to experience extreme hardship in case of your removal. Not everybody is going to meet that standard, especially for cancellation of removal. Some judges are extremely tough, and they will not grant a case, even if the case seems to be pretty strong. All right, so this opportunity of parole in place is going to help a lot of people. Those who are anxious about leaving the United States, those who do not want to be placed in removal proceedings just to try their luck, right? And also there is one more group of people who, in addition to unlawful presence, may have some other issues that may be fixed with a waiver in the United States. And I-601A waiver alone is not going to help them. So it's a good thing. Potentially, it can help, according to the news sources, I think more than 1 million people. That's the estimate, maybe even more, who knows, next week. So we spoke about this a couple of times already during my live sessions, and I received some questions. For example, what if you are in removal proceedings? Will you be able to apply for parole in place? Parole in place new rule has not been published yet. When it is published, I will be able to advise you better. But if I'm going to compare this parole in place with the parole in place that was issued for military personnel, I'm going to tell you that you will have to close your removal proceedings, ask the judge to terminate your removal proceedings, and then file for parole in place with USCIS, even though ICE has jurisdiction, should have jurisdiction to grant it as well. So termination or dismissal of the removal proceedings most likely will be required to be able to apply for parole in place. All right, what if you are, another question, what if you are already in the process of receiving a green card through marriage and it's very long? Will parole in place help you somehow? Not really. If you are adjustable and you filed for adjustment of status already and it just takes a long time, parole in place by itself doesn't make it shorter. Parole in place fixes only the issue of lack of legal entry to the United States, all right? So that's what parole in place is. Is it going to be helpful for many? Yes. Is it going to be helpful for everyone? No. If you do not have a US citizen spouse in the United States, you're not going to be able to benefit from it. That's the problem with the parole in place. So it's not for everybody. Not for every type of issue, but it will help a lot of people. We will. So we'll see. We're hopeful. We are hopeful that it's going to happen. And of course, if it does, I'm going to let you know. Now, guys, if you have your questions, I'll be very happy to answer them. Please ask your questions in comments. And we're going to discuss what can be done for each and every one of you. Hi, Lee from Chicago. Very nice seeing you. Hi, Ali, is there any update for undocumented immigrants living here more than 9 years? Not really, unfortunately. We just spoke about potential parole in place, but nothing specifically for people who simply overstayed their status and are not married to US citizens. But again, who knows? Maybe something will be announced. Thank you, Zulu, for your nice comment. Thank you very much. Thank you. Hi, Denny. It's been 6 months since USCIS received my response for medical exam and still didn't get a decision. How long do you think I should wait for? You know, Denny, I don't know what type of a case you have. It does seem a little bit long. All right, not sure what the issue is. Once I encountered an issue when the government asked for the medical exam, it was provided promptly, but then the case got stuck due to background checks. If you do not have and never had any criminal issues in your background, then you can push the issue of, come on, where's my decision? Perhaps by contacting the local congressman, okay? But if you had any criminal encounters, even if they were a long time ago, then consult with an attorney first. Guys, criminal arrests, criminal convictions never expire for immigration purposes, even the expunged ones. Hi, Raphael. Hi, VAWA. Thank you very much. Hi, Trudy. How can I apply for early adjustment with T status? What other documents needed? You would have to consult with an attorney based on your situation, if you can or you cannot. And I'm not sure what you're referring to about early, right? You do not want to wait for 3 years or something else. T status can be based on a variety of situations. For example, you reported a crime, but the law enforcement never got back to you, or they actually did get back to you and there was an investigation and you're actively still participating in investigation. So I think the best way to handle this question would be to show your file to an attorney, right? And see if you can or cannot do anything. All right. Hi, Donald. Hi, thank you for doing this. Does parole in place give you a travel document too? It gives you an opportunity usually to file for work permit. That's what current parole in place does. I'm not sure what's going to happen with this new announcement. I'm sure probably if it's going to be announced, you will be able to get the work permit just because it's deferred action that entitles you to the work permit. But travel permit, honestly, I don't think so, but we'll see, right? Hi, Isha. Good evening. EWI applied for OS since August 2022 through 245I. Will I be eligible for parole in place if it passes? I did receive my work authorization. If you're married to a US citizen and you would like to fix with a parole in place issue, the issue of lack of that paroled or inspected and admitted for adjustment of status purposes, and yes, sure, you can file for it. But if you already used 245I, you paid your $1,000 extra, right? You may not want to refile, especially if you said that you filed in August 2022, you already have the filing fees, right? You paid for the filing fees. Now filing fees went up. Filing fee for adjustment of status used to be $1,225. That included work permit and travel permit. Now it is $1,440. You pay $260 for the work permit, and I think close to $600 for travel permit, $620 if I'm not mistaken. So it became more expensive, and I don't see why would you want to do that. But again, I may not know certain things unless you're not sure about your 245I, then you would want to do it. Okay. Yeah, marriage-based green card. Yeah. All right. Hi, Sam Singh. Approve withholding or removal. Can apply for this, or should I close withholding or removal first only then? My guess would be that just if ICE is not going to have special powers to grant it, then you will have to first close the withholding or removal. All right. Let me see. Hi, Ramira. What are the immigration benefits can a family that is already in asylum immigration proceedings get aside from asylum? I have a special video about that. It's only basically humanitarian reliefs. If we talk about the family, such as U visa, T visa, things like that, usually. All right, let me answer some questions from my TikTok followers. Hello, guys. I have very, very, very active TikTok followers. Please share the stream, say hello, wave, send me some hearts. I know you have those hearts. Don't hold on to them. Hi, Matthias. Hi, Perez. Please type up your questions. I have 2 years with a lawyer and he hasn't done anything on my case. Hey guys, listen. I don't know if it's true or not, if they didn't do anything on your case. Maybe you do not know it, maybe they didn't show you. And both answers are wrong. 3 answers. He didn't do anything or she didn't do anything. They didn't show you what they've done. You do not know about it. When you work with an attorney, you should be staying on top of the case. They should share with you some elemental updates, right? I filed your case, here is the receipt. Now nothing is happening, we're waiting. Sometimes you have to wait for a long time and nothing is happening. Nothing is happening, right? So that's the update you're going to get. Why don't you meet with your attorney? Ask them for an appointment. If you have to pay for it, pay for it. Ask them what's happening with your case. If the attorney has not filed anything in 2 years, ask them why. Is it because the law changed? Do they believe it's not the best time for you to file? Are they preparing something else so that your filing is strong? Or if they literally took your money and do absolutely nothing, then you have to run from that office, right? It happens sometimes. It rarely happens, but sometimes. Hi, Rahman from Morocco. Yeah, Mecca, Saudi Arabia. That's really cool. Yeah, that's really cool. Hi, 369. If I have a deportation order and I'm married for 8 years, can I be approved for I-130? You can be approved for I-130 whether or not you have a deportation order. I-130, it makes it a little bit more difficult to get an approval if you have a deportation order or you are in removal proceedings, but by itself, it doesn't prevent you from getting that approval. What you need to worry about is the next step, your green card application form I-45, and that will depend on whether or not you're an arriving alien and whether or not you will need waivers, okay? And what do you want to do about it? Maybe you can submit for motion to reopen. Maybe you need waivers, something like this. So, can student file asylum and travel to other countries? Can student, once you file for asylum and you maintain student status and you are approved to travel, I believe you can do that and come back, okay? Hi, Khan. How long I-130 for overseas wife take? I have submitted in June. Usually within 9 to 11 months. It's just the first step. Hi, guys. Thank you for your hearts. Don't forget to send some hearts and share the stream. Thank you for your stars on Facebook, guys. So let's see what other questions we have. All right. Let's see how long I-130, right? We answered that. I applied for N400. Can I apply for sometimes? Hey, listen, I'm guilty of that too, misspellings. Sometimes I just try to read it real quick and I don't understand. I'm sorry, guys. But when I type fast, I always misspell words as well. Can I apply for a green card for my husband now? Of course, you can start the process if you're only a green card holder by filing I-130. But for your husband to get the green card, most likely you have to be a citizen. But because I-130 takes some time to be approved, and if you just want to, you're impatient and you want to start something for your husband now, you can file for I-130 now. I-130 is citizenship, not connected to each other. As long as you received your green card lawfully, all right? This is very important because during the N400 proceedings, guys, the government is going to check your file and make sure that everything that you stated there was true. Very, very important. If they find any kind of issue, they will not approve your N400. All right. Hi, Mr. Kaumer. Final hearing date canceled 2 times and no show in the calendar. What can I do? That's a very common situation. There is really not much you can do apart from following up with the court, maybe filing a motion to advance your hearing date if you have a very good reason for that. But in my experience, such motions are rarely granted. You need to know that. But again, if you would like to take a chance and you would like to proceed with it, you can do that. All right? All right. Hi, Abinuali. I am giving an expedited removal. I think I'm having an expedited removal order. I still have another appearance before the judge 2025. I'm giving an expedited removal. I'm not really sure what's happening in your situation, but if you have a future date in 2025, it means that you still have a chance, right, of fixing your status. So hire yourself the best lawyer you can afford and fight for your case, all right? Hi, Thunder Snow. Does this apply to those who entered legally but overstayed visa and then got married? If you're married to a US citizen and you entered legally and overstayed your visa, you don't need a waiver. The law automatically forgives you for working without authorization, for overstaying your visa, If you're married to a US citizen, so you don't need a waiver, you don't need parole in place. How I, the power of light, I brought my wife to USA on a fiancé visa, and then we got married. Is there a way to remove condition faster? No. If you're filing petition to remove conditions from her green card jointly, you must file within the prescribed by the law deadlines, which is 90 days before the second anniversary of her green card. But if she was to use a waiver of the joint filing, then she can file that petition at any time, doesn't have to wait for that window. All right. Hi, senior 123. Can my husband file for me on a green card, and how long will it take? If your spouse only has a green card, they can start the case for you by filing I-130, but you will have to wait for them to become US citizen to finish the case. Why? Well, for a variety of reasons, not just the law. Currently, if your spouse is a green card holder, you are facing about 4.5 years delay due to visa bulletin in visa availability. So you file for your case, and that's your priority date. If nothing changes with the visa bulletin, only 4.5 years later, you'll be able to use that filing, provided, of course, it's approved. So US citizen petition doesn't have this issue. Visas are always available. Does this apply to persons who applied for VAWA? Guys, if you are under VAWA proceedings, you applied for VAWA, you don't need parole in place. The law automatically forgives you for entering the United States without inspection, okay? Is there a way out of visa fraud? Of course, Shamonetta. It's called I-601 waiver, but you do need to have a qualifying relative to file for it, and that relative has to have extreme hardship in case of your removal, okay? I handled many of those waivers. If you are interested, I think I published some in my success stories, situations about the waivers. I had videos, how we won different cases. Immigration fraud is very common, guys. It shouldn't be happening, but it's happening. It's very common. Sometimes people intentionally create it. Sometimes it's a misrepresentation. They don't really understand what they're doing. They're using services of consultants and so on and so forth. So it happens. And for that reason, the government gives you an opportunity to ask for forgiveness or the waiver, right? I'm very successful with those waivers usually. I have good cases. If the case is very weak, I cannot accept it. I won't lie to a client saying that I can win a case it's not possible to win. If the client insists to try with a disclosure, we can, but there have to be some merit to the case. I cannot take a case that has absolutely no basis for it. You just have to understand. Most people will have at least some factors that can be used for the purposes of the waiver, such as, for example, hardships. Again, on my website, I have very detailed discussions and the videos on YouTube, how to win an immigration waiver that requires hardships, showing medical, financial, emotional, and some other hardships. Sometimes you have very unique situations. All that in aggregation is going to be looked at by the officers when they decide whether or not to give you that carte blanche for the green card, okay? Hello, my waiver I-601 pending since November 2020. I do not know what they want to do to approve it or not. Nasir, don't be upset. 4 years, I just mentioned that it takes for I-601 waiver that long sometimes to get a decision. It's upsetting, of course, that it takes so long, but it's the reality right now, all right? Hi, my TikTok followers, can you please share the stream and send me some hearts? Can we reach 1,000 hearts tonight? Hi, Manny. All right. I talked about the VAWA case. Let me see. Hi, Semjen. Good evening. Hi, Alena. My green card is taking longer. Do you have any advice for that? What can I do? It depends on how long exactly it takes. Okay. You can look at the processing times. If the card application, I-45 green card application is pending within the processing times and published processing times, I think about like 37.5 months, then there is not really much you can do. But if it's beyond processing times, first you have to submit an inquiry to USCIS, then you have to complain to your congressman. Finally, if you really insist, you can sue USCIS for these great delays in your case, okay? Hi. Burla Kori, American citizen child can file for mother who has TPS? Of course. I have a video on YouTube that in detail goes as to who can and who cannot get adjustment of status in the United States and why, so that guys, you will understand what's happening. If the mother has TPS, child can submit I-130, whether or not mother had TPS or not. I-130 is simply the ground for the future immigrant visa. During the I-130 process, all that is required is to prove that the child is a child of that particular parent. TPS allows the mother of the child to stay in the United States, to work in the United States, but also to apply for a travel document. Travel document on the TPS allows a person, upon their coming back to the United States, to be paroled. And if mother originally entered without inspection, now that particular issue will be cured. Now, what if mother also has an order of removal? Well, then after she comes back, using that travel document that she received based on TPS, she's going to file a motion to reopen with the court, asking the court to reopen and terminate the proceedings. Now she's adjustable, right? That's how it works. That's how it works. Let me take one last question, guys. I hope you're all doing great tonight. Hello, Alena. I was wondering if a son of a lawful permanent resident of a state, can he file I-601 along with I-45 when the immigrant visa becomes available? Son of a lawful permanent resident of a state, I-601. No, I-601 is not going to cure it. I-601A may help here, right? But I-601 waiver is not going to cure the issue of the overstay unless something is missing in this situation. Why? Because if you are adjusting in a preference category, you're subject to 245C bar that says that you must be in lawful non-immigrant status throughout your stay in the United States, and I-601 waiver does not cure it. Well, guys, thank you very much for joining and your comments, watching. Hopefully this live is a little bit helpful for you to understand what's happening. In any event, if you are somebody who is married to a US citizen, or you know someone who is married to a US citizen, and you guys do not have papers, right? Or that person doesn't have papers because they do not have legal entry, then you have a very good chance of fixing it if parole in place is going to be announced. All right, so rewatch this video, share it so that other person is going to know about this opportunities. They can get ready. I have another little video that explains how to get ready, and we're going to be hopeful, and I'm going to share updates next week, so don't forget to sign up for my channels. And we're going to have the discussion once the exact conditions of the parole in place are announced. Thank you very much, guys, and have a great, great weekend.